global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happiness Today YouTube channel. As Nigerians await the verdict of the PEPT, that's Presidential Election Petition Tribunal or court, there seems to be a lot going on where Senior Advocate of Nigeria, Olanipakun, is a key player in that particular verdict. But before we go into the news proper, we'd like you to subscribe to our channel by clicking on the red subscribe button beside it. You say bell notification icon. Please go ahead, click on it to get notified as soon as you update our channel on YouTube. Well, let's quickly hit the ground running. Now, the Court of Appeal Lagos Division has voided a Federal High Court decision that mandated the Independent National Electoral Commission (INEC) to electronically upload results of the governorship and state of assembly elections from the polling unit directly to the result viewing portal, that's RF. Now, a three-man panel comprising Justice Abubakar Omar, Justice Olukayode Bada, and Justice Onyekachi Otise held that the law gave INEC very wide discretionary powers to determine how it transmits or transfers election results. Now, the judgment delivered by the panel on July 19 and obtained described the suit filed by the Labour Party at the lower court, which gave rise to the appeal as an abuse of court processes. Now, on March 8, 2023, the Labour Party, its governorship candidates in Lagos, Gbadebo Roy, Vivo, and 41 others obtained the order of Mandamus from Justice Peter Laifo of the Federal High Court, Lagos, to compel INEC to obey the Electoral Act and its guidelines for the conduct of the elections. Now, Justice Laifo directed INEC to comply with and enforce clauses 37 and 38 of the regulations and guidelines for the conduct and governorship and State House of Assemblies in Lagos State and others. Now, the clauses mandated presiding officers of all polling units to paste the publication of result posters at the polling unit conspicuously after completing the EC8A result sheet. Now, the order also mandated the presiding officers to electronically transfer the results of the polling unit directly to the collation center and a scanned copy of the EC8A to INEC RF immediately after the completion of the polling unit voting and result procedure. Now, Justice Laifo's judgment also directed INEC to observe, comply, and enforce the provision of Section 27, Subsection 1 of the Electoral Act 2022 in the distribution of electoral materials during the elections by engaging the services of non-partisan, independent, and reliable logistics companies. Now, dissatisfied with the decision, the All Progressive Congress (APC) and Social Democratic Party (SDP) sought leave of the court to appeal the judgment and eventually filed their notices of appeal as interested parties. Now, the APC, in its written address filed by its team of lawyers led by Chief Wole Olanipakun, Senior Advocate of Nigeria, SAN, said despite not being joined in the suit, it had deemed it fit to appeal the judgment because it was aggrieved by the decision, which it said would affect its interest as a sponsor in the same election as the SDP. Now, the first and second respondent in the suit were Labour Party and Royce Vivo, while INEC was the 43rd respondent. Now, the APC noted that the Labour Party had earlier filed a suit against INEC at the Federal High Court Abuja, where it raised the same issues and sought similar reliefs, which is litigated and resolved at the Lagos division of the court. Now, the appellant court in its judgment noted that the Labour Party, its governorship candidate, and all other respondents did not file any brief to join issues with the APC despite being served with the briefs. Now, specifically, the APC asked the court to determine 4 issues. 1. Whether by Section 50, Subsection 2 and 14 and 148 of the Electoral Act 2022 and clauses 37 and 38 of the regulations and guidelines for the conduct of election 2022, the lower court was right when it held that the presiding officers must electronically transmit the figures of election results from various polling units and thereafter proceeded to grant an order of mandamus compelling the 43rd 43rd respondent, which is INEC, to comply, enforce and abide by the provisions of clauses 37 and 38 of the regulations and guidelines for the conduct of elections 2022 for the conduct of the governorship and House of Assembly elections in Lagos State, when the substantive law pursuant to which it was issued grants unqualified discretion to INEC to determine and prescribe the mode by which election results are polling units may be transmitted, including options of manual or physical transfer of results. Whether the land judge of the lower court misdirected himself and acted without jurisdiction when his lordship proceeded to hear and determine the originating summons filed by the respondent at Lagos Division of the Federal High Court on matters hinging on the conduct of the 2023 general election as opposed to the Abuja Division of the Federal High Court. Now, whether considering the weight of evidence before the lower court, the judgment of the land judge of the lower court is not a nullity considering the absence of all other necessary parties in the suit. Whether the action of the first respondent having earlier litigated suit number FHC/ABJ/CS/154/2022, the issues which it thereafter litigated with the second to 42nd respondent at the lower court in suit number FHC/L/CS/370/2023 is not an abuse of court process. On issue 1, the appellant submitted that by the provision of Section 50, subsection 2, 27, subsection 2, 60, subsection 5, and 148 Electoral Act 2022, as well as paragraph 15, subsection A of the third schedule to the 1999 Constitution, the 43rd respondent, which is INEC, has unfettered discretion to determine how to transmit result either by uploading the scanned copies of Form ECS8A to its RF or to manually transmit the result, and the discretion is not subject to an order of court. The lower court was therefore wrong to have held that presiding officers must electronically transmit the figures of election results from various polling units and thereafter proceeded to grant an order of mandamus compelling the 43rd respondent to comply, enforce and abide by the provisions of clauses 37 and 38 of regulations and guidelines for the conduct of elections 2022 APC maintained. And the appellant added that clauses 37 and 38 regulations and guidelines for the conduct of elections 2022 are subsidiary legislation and cannot override the principal act which grants INEC discretion. Counsel further submitted that an order of mandamus cannot be granted to filter discretion relying on Dododo versus EFCC 2013, 1 NWLR PT 1336 468 paragraph D to E, adding that INEC decisions enjoy presumption of correctness and the onus of providing the contrary is that of the first to 42nd respondent. And the appellant argued that the lower court relied on the Presidential and National Assembly election 2023 guidelines to make its order when the appellants are not candidates in the election. Now, relying on McFoy versus UAC 2013, Limited 1962, 150 at 160, counsel contends that the order of mandamus granted by the lower court has no pedestal to stand on and cannot therefore stand, APC declared among other prayers. Now, its decision, the Court of Appeal noted that the Labour Party's governorship candidate and all other respondents did not file any brief to join issues with the APC despite being served. Now, the court held that Section 50, subsection 2 and Section 60 at the Electoral Act 2022 give INEC a wide discretionary powers to determine how it carries out its assignment, including the manner it transmits or transfer election results from the polling unit to the collation center. The appellant court held that although the Justice Lightfoot premised his decision on clauses 37 and 38 of INEC regulation and guidelines, the Electoral Act gives the Commission flexibility to amend or vary its regulation. Please take note of that particular one. Let's continue. Now, Justice Umar now said It is my considered view that the power to make a regulation or guideline necessarily entails the power to amend or verify it, or vary it rather, especially if it deems it necessary or exigencies warrant such. Now, with due respect to the learned judge, an order of mandamus cannot be granted to fetter discretion. The judge also held that not even the allegation that INEC breached its own regulations during the conduct of the presidential poll can justify the order of mandamus issued by the lower court, because that is an issue for the election tribunal. Now, the appellate court also averted its mind to the decision of Justice Emeka Nwete of the Federal High Court of Abuja and agreed with APC that the suit in Lagos was an abuse of the court process. Now, in the suit, Justice Nwete, while delivering judgment, held that INEC was at liberty to specify or pick the method of transmitting election results. Now, the appeal court said that it found merit in the appeal and therefore resolved the issues in favor of APC. Now, all those places I deliberately emphasized by virtue of my reading clearly shows you why the senior advocate of Nigeria, Chief Wole, and Olanipakun went down there. Remember, all of this, Nigerians have been screaming and shouting. The mode of INEC transmission of results was more than important. Don't forget that all the tribunal cases, Peter Obio, Labour Party, PDP, if you watch how their senior advocate of Nigeria judges, their legal luminary presented their case, you would see that they took their time. Now, they have already gotten order of mandamus from Lagos. That's for the likes of Vivo, Labour Party. But now, Chief Olanipakun had to go down there to ensure that doesn't hold, because let's put in our comment section. Hey, all eyes are truly on the judiciary. Please, Nigerians are truly waiting. All this go here, come there, adjust here. They should please, for the sake and the love of Nigeria.